Hello and welcome to LAWSENSE. My name is Chanza Sikazwe and I'm from Chanza Sikazwe Advocates. We're legal practitioners, commissioners for oaths, and we're also notaries. Don't worry about the way I'm looking. This is LAWSENSE and this is Judgment Day on LAWSENSE. We're discussing the Supreme Court of Appeal decision concerning the government of the Republic of Zambia and the Esther Lungu and her family as regards the burial of former late President Edgar Lungu. The decision was delivered recently, yesterday in particular, and we're looking at the majority decision of the Supreme Court of Appeal of South Africa. In case this is your first time to watch this, take note that this is part 3 in a series of videos done in connection with the matter relating to the government and the Lungu family. You can watch part 2 to look at the arguments that the parties brought before court. This particular video restricts itself to the reasoning that the court gave as regards the arguments given by the parties and the decision that is ultimately given. So let's begin by discussing the legal points that the court held and decided upon. The first thing that the court delved into was the aspect relating to the former President's Benefits Act of 1993, a Zambian piece of legislation, a Zambian Act of Parliament, and the court stated as follows. The core issue in this appeal is whether the High Court correctly concluded that the Zambian government had established a clear right to bury the late former President Lungu, contrary to the wishes of his family. One question that may be disposed of immediately is that of the Benefits Act and the Zambian government's pleaded case that this legislation is the source of its right. Contrary to his pleaded case at the hearing of the appeal, counsel for the Zambian government expressly eschewed any reliance on the Benefits Act. This concession was correctly made. In the first instance, the late former President Lungu had been stripped of all his benefits under the Act while he was alive. The letter of withdrawal makes it quite clear that his benefits were terminated. They were not, as the Zambian government contended, merely suspended and revived on his death. In any event, while the Benefits Act places an obligation on the Zambian government to reimburse a deceased former president's family for funeral expenses, none of its provisions give the Zambian government any entitlement to make decisions about their burial. There was thus never any merit in its contention that the Benefits Act accorded it a clear right to bury the late former President Lungu, contrary to his wishes and those of his family. The next issue that the Supreme Court of Appeal decided on was the South African constitutional rights of the family. And it stated, the Zambian government accepts on appeal that the family is entitled to rely on their constitutional rights based on their presence within South Africa. This is consistent with long-standing constitutional court authority that the Bill of Rights applies to all people in South Africa, regardless of their nationality. In addition, the Zambian government accepts that the contractual issue must also be determined by applying South African law. This, too, is a concession correctly made. All of the conduct relevant to this issue took place in South Africa. What is more, the Zambian government took no steps to tender evidence on the Zambian law of contract. Consequently, the only law that can apply to this question is South African law. There is thus no conflict of laws question on the contractual issue. The third issue that the Supreme Court of Appeal also dealt with was the government of the Republic of Zambia's reliance on Zambian custom and practice. And it said as follows. In respect of the Zambian government's reliance on Zambian custom and practice, too, there is no true conflict of laws question. This is so because, as pointed out by the family, no evidence was tendered to establish the requisite legal principles the Zambian government relies upon. A party relying on the application of foreign law must prove the content of that law as a matter of fact. This requires evidence tendered by an independent expert. It follows that a party may not be an expert in its own proceedings. In the absence of expert evidence to establish the content of any foreign law, relied on by a party, it is presumed that the foreign law is consistent with South African law. Mr. Kabesha averred that in Zambian law, the burial of a former president is treated as a public state event, integral to the Zambian national identity and constitutional heritage. Consequently, he averred the Zambian president has the final say in the burial of a deceased president. As evidence of these legal principles, Mr. Kabesha relied on his own professed experience, stating that I consider myself to be an expert in the field of Zambian law, and I respectfully confirm that the Zambian legal principles set out above are correct. Perhaps appreciating that confirmation by an independent expert would be necessary, Mr. Kabesha stated that Mr. Mutemwa, a counsel in private practice, confirmed the correctness of the principles stated. There was no confirmatory affidavit from Mr. Mutemwa. Consequently, the only evidence of the Zambian law relied upon by the Zambian government was that stated by the person who instituted the proceedings on its behalf. There being no admissible expert evidence to establish these principles, in effect, South African law and South African legal principles apply. For this reason, too, there is no true conflict of laws question at play in the dispute. The Supreme Court of Appeal in South Africa also went on to isolate two questions as follows. Number one, what are the respective rights of the parties under common law, as understood within the context of appropriate constitutional rights and principles? Number two, in the event that it is the family who has the right to decide on the burial of the late former President Lungu, was the High Court correct in finding that the family was contractually bound to permit the Zambian government to repatriate and bury his remains? The Constitutional Court proceeded also to discuss the issue of the South African common law and constitutional position. And it stated, for decades, the accepted common law position stated in several provincial division decisions has been that in the absence of directions from the deceased, decisions regarding his or her burial fall to the heirs in accordance with the principles of succession. This accords with our Constitution, which recognizes the right to privacy and dignity. A family's right to decide on the burial of a loved one falls within the inner sanctum of an individual's family life. It is an exercise of family autonomy, involving the final act of kinship family members will perform for their loved one. Any interference impacts upon the family members' sense of self-worth and self-actualization, and consequently their dignity. Of significance in this appeal is the fact that the burial dispute in question is not one between competing family members, as is most often the case. Instead, it involves the claim to a right of burial as an exercise of public power by a state against the avowed wishes of the affected family. In this situation, courts are enjoined to ensure that the constitutional rights of Ms. Lungu and those of her family members are protected against the exercise of excessive state power. Absent a clear and convincing legal basis for finding differently, it would not be constitutionally permissible for the Zambian government's interests to override those of the family. However, the difficulty for the Zambian government is that the Kaunda judgment does not refer to any evidence of the content of these protocols. The dictum goes no further than recording the understanding of Mumaje, who presided over the matter. In the absence of admissible evidence establishing the protocols governing state funerals in Zambia, the Kaunda judgment does not advance the Zambian government's case that protocol and custom give it the right to bury the late former President Lungu. There is a further difficulty with the Zambian government's reliance on the Kaunda judgment. The Zambian High Court expressly found that there is no empirical evidence adduced in relation to the wish of the deceased. That is not the position in this appeal. Although there is no written record of the late former president's burial wishes, Ms. Lungu and other members of the family aver that up to the time of his impending death, he consistently instructed that the Zambian government and President Hichilema in particular should play no part. According to Ms. Lungu, he expressed his wish outside the family circle to Dr. Sishua in an interview shortly before his death. Dr. Sishua furnished a confirmatory affidavit in that respect. The Zambian government sought to place doubt on the family's averments regarding the late former President Lungu's burial wishes. It contended that the family's version was irreconcilable with the late former President Lungu's desire for a state funeral. The Zambian government does not lay a factual basis for this allegation. It is so, as the Zambian government was at pains to point out, that there is no evidence to suggest that the late former President Lungu expressed any wish to be buried in South Africa. In my view, this is not a determining factor. What is patently clear is that all the evidence points to the late former president's expressed aversion to any involvement by President Hichilema in his funeral and burial. His concern was with the manner of his burial, not the place thereof. If he cannot be buried in Zambia without the involvement of President Hichilema, the obvious alternative was a burial outside that country. The late former president spent his last months in South Africa. Ms. Lungu avers that he realized that he would never return. Ms. Lungu and family members were in South Africa with him in the final months. They retain a physical presence here, albeit that they have not moved here permanently. The family's decision is not unreasonable and is consistent with the late former President Lungu's primary concern, namely the exclusion of any involvement by President Hichilema in his funeral and burial. The family's evidence in this regard does not stand in isolation. It is consistent with the undisputed evidence of his treatment by the Zambian government in the 3 incidents in September 2023 referred to earlier, culminating in the decision to strip him of the benefits of his former office. The family were the respondents in the application before the High Court. Applying the Plascon Evans Paints Limited versus Van Rayback Paints Pty Limited approach, the family's version must prevail. It must be accepted that it was the late former president's wish that President Hichilema would not be a welcome presence at his funeral. This is very different to the Kaunda case, where the Kaunda family initially objected to the late President Kaunda being buried at Embassy Park. The Kaunda family later agreed to a burial at Embassy Park with the late former President Lungu in attendance as head of state. There is nothing irrational about the family's position. They are honoring the wishes of the late former President Lungu by refusing to permit a repatriation and burial by the Zambian government. The late former President Lungu represented a particular political community. This attracted the ire of the Zambian government. His expressed burial wishes are consistent with the interests of the community he represented. They are also consistent with his own sense of dignity and, by extension, that of his family. As such, the constitutional principle of Ubuntu supports rather than overrides the need to respect his burial wishes and the family's decision to honor them. The family consistently disputed that it had reached an agreement on terms stated by the Zambian government. It contends that it was the Zambian government which, at the last moment, imposed a condition that the family found unacceptable, namely the involvement of President Hichilema. On the tried principle applicable to material disputes of fact in motion court proceedings, the families deny that it concluded an agreement on terms relied on by the Zambian government must be accepted unless it is so far-fetched or clearly untenable so as to be rejected. It is common cause that there were ongoing negotiations between the parties, with the exchange between them of several proposed programs over a period of approximately 2 weeks after the late former President Lungu's death. These were revised, and at least one was withdrawn by the Zambian government. What is consistently unclear from all these versions of proposed programs is the role of President Hichilema in the proceedings. In the absence of a definitive evidence from the Zambian government that the family had agreed to renounce a strongly held position on President Hichilema's involvement, the family's version that there was no agreement must prevail. For these reasons, I find that the High Court erred in concluding that the Zambian government had established a contractual right to an order directing the repatriation of the late former President Lungu's body for purposes of a state funeral in Zambia. The Zambian government's failure to establish a right under either the common law or contract to override the family's burial decision is fatal to its case. The High Court erred in finding that the Zambian government was entitled to relief. It ought properly to have dismissed the application. The appeal must be upheld and the order of the High Court set aside. There is no reason why costs should not follow the result. I make the following order. Number 1, the appeal is upheld with costs, including the cost of 2 counsel where so employed. 2, the order of the High Court is set aside and is replaced by the following order. The application is dismissed with costs, including those of 2 counsel where so employed. And that is the judgment as delivered on behalf of the Supreme Court of Appeal by Judge R.M. Cately, Judge of the Supreme Court of Appeal. So that's the judgment. So the question is now, what is the way forward? We have received official communication from the Office of the Attorney General, Mr. Mulilo Kabesha State Counsel, indicating that the government shall not appeal this judgment that we have just referred to, which means that the family now is at liberty to decide on where the burial is going to take place, whether in South Africa or indeed in Zambia or indeed elsewhere. It is now the family's decision to make, and we all await to hear what the family has decided. Well, this has been LAWSENSE, Judgment Day. My name is Chanza Sikazwe. I hope that we've been able to exchange some LAWSENSE during this period. Until the next episode, it's bye for now.